exact same material. Our request for sanctions, we believe, is very reasonable. We're not asking for a mistrial. We're not asking to delay this trial. But there's got to be sanctions imposed, otherwise the law and the court's order are meaningless.
Your Honor, may I respond?
You may.
I would note that what I have been provided, which we were not notified of before trial and had no opportunity to verify its authenticity, but what I've been provided is a record from the city of Round Rock, and I am having trouble finding a date. Okay, the date is December 19th of 2018. Thus, I have no idea whether this was currently in effect at the time of this incident in late March of 2019. And the incident that it appears to apply to is an expired vehicle registration. And we have not had any opportunity to verify whether this was the case or to determine whether or not this was still in effect at the time of this incident on March 28th of 2019. But I would argue that whatever we provided in discovery, which was everything that we had or were aware of, was sufficient to notify the defense to look this up to the extent that they did. And again, I do not even know if this is something that was still in effect at the time that he was pulled over. It is a very minor traffic-related incident. Expired vehicle registration, and to be honest, Your Honor, I was not aware of it. If it was in effect, I was not aware of it. What I would also say is that I have previously researched the appropriate remedy for a discovery violation. And this type of sanctions are not authorized. What I would say is that the usual situation is one of two things. It is a continuance so that the defense can have time to react to information. In this case, it sounds like they already have obtained this information. And the other potential remedy that courts would typically offer would be to prohibit the state from introducing evidence of that particular matter or related to that particular matter. So to the extent that the defense has argued that the state should not be able to argue or present evidence that the victim in this case, Javier Ambler, had no pending warrants for any kind of offense, which would encompass a traffic offense, then I would agree that that might be an appropriate remedy. Although at this time, I still am unaware as to whether, and have not had an opportunity to research as to whether this was pending at the actual time of the offense.
But if this is true and this was pending, it's potentially exculpatory, right? Would you agree that if there was an active warrant pending at the time, that is potentially exculpatory evidence? Do you agree with that?
I would only agree with that if the officers involved were aware of it. And I don't think that there's any evidence that they were. In fact, the CAD reports that we have indicate that they ran checks. All of the evidence that we have is that they ran checks, and like us, this did not show up. Probably because it was an expired sticker out of Round Rock, and possibly because it was no longer an issue. It may have even been already paid or resolved.
The government's asking you to believe that after 5 years investigating the case, they're not hiding evidence, they're just incompetent. I don't believe that. They had 5 years to find this exact evidence and produce it like they're required to under the law. This is why we have the Michael Morton Act. They failed to do that. And now they come into court, the remedy is somehow that the warrant be excluded from evidence. That serves their purpose. That's why it was hidden in the first place. There has to be meaningful sanctions, otherwise this kind of misconduct continues and continues.
Yeah.
We're not asking, the court will remember, prosecutor, district attorney Ken Anderson spent time in jail for hiding evidence. We're not asking Ms. Taylor or Mr. Garza or anyone to have to serve jail time. We're asking for very reasonable sanctions in this case.
Your Honor.
We have no objections if you want to allow the government to take an hour to go find in TechShare, because we've given them a map of where they had notice and where they provided notice to the defense that this existed.
I think he just stated that we provided notice to the defense that this existed. That's number one. He just conceded that. I think our sin, if we have one, is failing to go and actually look up this data. And respectfully, what I said was not that we wouldn't produce any evidence of this. What I said was that we wouldn't make any statements to the jury that there were no pending warrants in the event that we determined that this was in fact pending. We would definitely agree that we could not present evidence that there were no pending warrants if in fact this thing for an expired vehicle registration was pending at the time. That's what I said would be an appropriate remedy. But at this point in time, the state does not even know if this was in fact pending at the time. But if it was, we certainly, I think it would be an appropriate remedy for the court to prohibit the state from offering evidence that would be contradictory to this. And I think that would be an appropriate sanction if that were the case. But I think that Mr. O'Connell just conceded that the state did provide them with such notice.
Judge, I've given you the roadmap of where the notice was placed into TechShare. Mrs. Taylor misses the point. The government has an affirmative duty to go out and produce evidence. They had 5 years to go get this warrant and turn it over to the defense, and they failed. Whether they gave us a snippet of notice is not the issue. They have failed under the law, and they failed the court's orders.
So, Mr. O'Connell, just so I'm clear, but the way you found this warrant was through discovery that the state did give you. It was just in a zip file that you then opened separately. Am I wrong?
Well, so I want to be precise in what I say. This case is so old, we don't have a clear memory of when and how we learned. But our best guess is that we got the criminal history data from the state. On page 11 of one of those files, there is the warrant entry snippet that I've provided to the court. And with that in hand, we believe we sent an investigator to Round Rock Municipal Court and obtained the warrant.
Your Honor, I just had an opportunity to evaluate what counsel just handed me, okay? And what I want to say is that this first page, which is an Excel spreadsheet type table, is one that I can tell is printed out using the TechShare program, which is the automated discovery program that the state uses. And you will see on the third line, which the defense has conveniently blocked out in red for us, that Javier Ambler.zip folder was made available to the defense on March 30th of 2021, 3 years ago, approximately. It also appears that it was initially accessed on February 20th of 2024 by the defense. And if you page through, you will see that in that zip file were 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 items. One of them is called History from Wilco. And the third page of what the defense has provided to us, which Mr. O'Connell referred to as page 11, appears to be that History from Wilco. And on that page, in very tiny print that I would need my readers to look at, is an item that is highlighted below, which says warrant. The event date is 12/19/2018, and it says operate unregistered motor vehicle relationship wanted, okay? So it looks to me like this was 100% disclosed to the defense, and that the state provided the defense with notice that there was some type of warrant that was active from December of 2018 for operating an unregistered motor vehicle. And that appears to be the notice that was provided, and then the defense went and got a printout from the relevant records, which says that it was an expired vehicle registration sticker. So it appears to me that the state provided notice of this, and we did so back in 2021 in March, and that the defense did not actually access it to ask about the individual record of a very minor traffic offense until February, late February of this year, in fact, the day that jury selection started in this case. So I would question whether sanctions are even appropriate, but if they are, I certainly think it would be appropriate to prevent the state from saying that there were no active warrants for any kind of offense. Maybe no active felony warrants is appropriate, but certainly this Class C misdemeanor, there may have been some sort of active warrant for this expired registration sticker in March of 2019.
May I address when we've known about this, or do you?
Yeah.
So, we've known for some time, certainly longer than February of this year. Keep in mind, Your Honor, there's two tech sheriff files, one for Zach and one for JJ. And this data was disclosed in both files, so my guess is we've been looking at the other file. But again, Ms. Taylor's missing the point. We've provided you a brief in support of our motion drafted by Mr. Roundtree that provides the legal basis for what we're asking for. And again, we have no objection if you want to give the government some time this morning to sort out what they did and what they failed to do. But we're asking that the jury be admonished prior to opening statements.
What is the admonishment that the defense is requesting?
It's in the motion.
It's on page 2 of their defendant's motion.
Your Honor, this feels like an attempt at a gotcha. We were served with this very thick motion this morning, and we had conversations with the defense before proceedings started in which we all shared the matters we thought we needed to cover with the judge before the jury came in. They did not mention this. And it's a gotcha, which is rather ironic given that the state appears to have notified the defense of this 3 years ago in March of 2021. I haven't even had a chance to read this document.
Okay, I'm going to take a recess in a minute to address that. Before I go back, though, leaving that on the table for now, are there any other issues that you need to be thinking about that we need to address?
Yes, Your Honor. The state had several issues which the state shared with the defense before we started.
All right, Ms. Taylor, go ahead.
I just wanted to say, in accordance with the court's instructions, that we have provided a list of our exhibits and a list of our witnesses, both to the court reporter and to the defense. Obviously, those are subject to change, as I'm sure the court knows, as trial proceeds. I wanted to first make a record that we have done that. Second, we filed the stipulations and the Morton form. I want to address with the court at the out-of-state witnesses that the court issued certifications for, as you may recall, on those out-of-state subpoenas. There was a hearing that was held in Riverside County, California, on Friday regarding the contention of 2 of those witnesses that they not be forced to appear here in court for this trial. The judge in California, and I want to say that I made the defense aware of this hearing. We were able to participate via Zoom. I sent the defense an email with all of the information so that they could have logged into that hearing, and they did not. I did. And the hearing proceeded these two witnesses who are members of the live PD crew that was working with Williamson County at the time of this incident. They appeared in court, and they made their case as to why they should not have to appear here. These were Colin Micah and Kate Purcell Micah. They are a married couple who were members of the live PD crew. They made their case that they were not fact witnesses, although actually when they appeared, I think their attorney did concede that Colin Micah was a fact witness. As the court may recall, Mr. Micah was the cameraman who was accompanying James Johnson that night and was positioned right behind James Johnson during these events. I believe that their attorney essentially recognized that he was a fact witness. The judge in California did find that he was, and did order him to come here and appear. So he will be here to testify this week. But with regard to Kate Micah, the judge there, they presented their case that they have a 12-week-old infant with some significant health issues, and that Ms. Micah herself is suffering from some health issues due to a recent, difficult labor and birth with the 12-week-old infant, and that Ms. Micah was not directly present at the time of the in-custody death. As the court will recall, Ms. Micah did have a role to play in this, and that she was the lead producer for the live PD crew. She also came to the location, and allegations are that she took the live PD footage and mailed it to New York. I made this, because the defense did not appear at the hearing, I made it clear to the judge there that although we were sensitive to Ms. Micah's situation and health issues and her infant's situation, that there was a spoliation claim that we knew from pretrial proceedings would be raised by the defense in these proceedings, and that we expected that Ms. Micah's testimony would be something that would be relevant in our proceedings for that. The reason having to do with the live PD footage. The court considered, he took a break and considered all of the issues. He ultimately came back and ruled in Ms. Micah's favor, largely due to the hardship, the compelling hardship claim that Ms. Micah had raised. I have informed the defense of this. I'm informing the court, and so that's what happened in that hearing. In addition, I will let the court know that ultimately, although there was some difficulty in serving them, the other members of the live PD crew, including Mr. Jeff Moriarty and Ms. Ruby Garson-Tarzian, were served and will be. We do expect that they will be here to testify if everything goes as agreed. With regard to these issues, though, the court may recall that Mr. David Gonzalez, local attorney, is the local counsel for these live PD crew members, and I have been in communication with him. Mr. Gonzalez would like to request that because it has been a few years since these witnesses previously testified in the capacity that they did, that they be provided with that transcript so that they can review it. And Mr. Gonzalez would like to speak to the court about that. Unfortunately, as circumstances would have it, Mr. Gonzalez is currently litigating a murder trial in another court in the courthouse today. So I expected that he might be here with us now or before we started. He obviously was not able to be here. He may be here tomorrow morning, and I'm just letting the court know that he does want to approach the court to discuss protective orders related to the matter that we discussed.
I'm inclined to allow that, and I don't think the defense doesn't have any objection to that.
We don't, Your Honor. This is the state's issue, so.
Yeah.
So,
if he just wants to have someone send me the protective orders that need to be signed, I can do that. He doesn't need to appear.
Thank you, Your Honor.
Okay.
With regard to, my understanding is that the defense intends to invoke the rule in these proceedings.
Invoke the rule at this time.
Okay.
Your Honor, I wanted to address with the court potential exemptions from the rule for experts for both parties who are not fact witnesses. In other words, use of force experts and medical experts who are not, for example, the medical examiner, who is a fact witness, as well as an expert. So the state's request would be that the court exempt both parties' experts from the rule. That's our first request.
Any objection to that?
We would agree.
Okay.
Okay, again, with the exception of people who were actually fact witnesses involved in the case, such as doctors who treated the victim, and EMTs and the medical examiners.
Just the expert witnesses of.
Yes, thank you, Your Honor. And our other request respectfully for an exemption would be for the parents of the victim, Mr. and Mrs. Ambler. They are not designated as witnesses in the state's case in chief, but it's purely theoretical, but were they to be called a punishment as witnesses. They were not present at the scene. They're
not fact witnesses.
They're really not fact witnesses in this case. So we would request that they be exempted from the rules so that they can be present here in the trial having to do with the death of their son.
Did you guys have any objections?
No objection.
Okay, they are exempted as well.
Additionally, the state wants to update the court on the jury charge. The court had asked the state to prepare a draft jury charge. We have prepared a draft jury charge. I wanted to let the court know that we completed it on Friday and submitted it to our appellate division for review to ensure that everything is legally correct, Your Honor, and we will be providing it to the court as soon as that review is completed, which I expect to be very soon, so that the court can review it and have staff attorneys review it.
If you can just copy Delaney on it as well, and copy the defense, and actually copy Kimberly Donahue, staff attorney.
Certainly, and of course, we will always copy the defense, but we will copy Delaney and also Kim Donahue, the staff attorney. Additionally, and this is just sort of a housekeeping matter, the state plans to, as we understand the court's standard practice is to offer items such as photographs in a physical form. And we ask the court's permission to also display the same image on the screen so that it can be published in a way that's convenient for the jury to view. But we will submit a physical item. Do I have the court's permission for that? Thank you. Additionally, one more matter, which is that with regard to the state's motion in limine number 9, and I realize that the state had the court may not have committed the state's motion in limine to memory.
You're right.
Yes. I would say that this one is the one that had the language about basically alluding to no bills. And so we would retract that motion in limine, or withdraw the portion of that motion in limine specifically that refers to the no bill of Officer Michael Nissen. And the reason for that, well, we would just do that.
Okay. That's fine.
I think that it is a matter that it will be difficult for the parties not to discuss in these proceedings that concerning that process with Officer Nissen. But that's all with regard to that item.
Okay. That's noted. Is that all?
I believe so, Your Honor.
Okay. Anything else? Mr. Irvin?
Yes, Judge. This concerns the state's motion in limine. There are a few items that, as instructed, we are approaching the court about prior to discussing opening. We would like to get into some specific things. These would go to numbers 4 and 23 on the state's motion in limine, but we'll be able to figure it out. It's Mr. Ambler's 404B. What we would like to get into is the traffic offenses that he committed during the 22-minute chase. The fact that he had an active warrant at the time of this incident, and the fact that he had evaded before successfully. We've got documentation and reports and witnesses ready to explain that and support it. Further, that he was a known drug dealer, and that dash cam footage from Mr. Johnson appears to show Mr. Ambler throwing objects out of the window. Candidly, we don't know what they were, they weren't recovered, and it's not obvious what they were, but we've highlighted those in the video. The allegation that he was a known drug dealer comes from a person who was an associate of Mr. Ambler, who we interviewed years ago, and who we have subpoenaed for trial, and who was on the hook to come and tell the court and the jury what he told us regarding that.
When you say no drug dealer, are you saying that your clients knew he was a drug dealer?
No. This goes to refute the idea that Mr. Ambler only failed to dim his headlights. He ran for other reasons.
Mayor, number one, we dispute the charges concerning drug dealing or anything of the sort. And certainly the evaded before, I think what we're gonna need to do is approach at that time so that the defense can present whatever evidence that they have gathered. There's certainly information in the file that the state has provided, but I would say that none of it has been verified or anything of the sort. And I would be happy to have a conversation with Your Honor about it at the time, but this is not something that there's no convictions, there's no record, there's no information that these defendants were in any way aware of these vague allegations, and I think it's something we should approach on.
Here's what I will allow, is any other traffic violations after the failure to dim headlights that were witnessed during the time that the chase was occurring. I have no problem with that. I also have no problem if they're, I'm not going to allow known drug dealer for now, and I might not at all, but to the extent there is video evidence of things being tossed out of the car, we don't know what those are, but I will allow, without saying, you know, kind of imagining or, you know, what they might be, I will allow the defense to point out any time that they think that something is being thrown out of the car, but you know, you don't know what it is. So, and I'm not going to allow you to speculate what it is.
Your Honor, certainly, I think that the court has been very clear all along that anything that happened that night is fair game. So certainly to the extent that the defense can try to show from the video that something was or was not thrown out of the car, the state certainly would not dispute that. That's part of the transaction that occurred in this case.
But the prior evading, I mean, that is classic 404B. They evaded before, therefore, I mean, that's just classic 404B. So I'm not going to allow proof of any kind of prior evading charges.
Judges, for clarification, is offering this for the purpose, again, of motive, to refute the widespread allegation that Mr. Ambler only failed to dim his headlights. We have confirmed that he had evaded before. We have the documentation, we have the witnesses. The state hasn't, and perhaps they should have done that in the last 4 years.
Your Honor, I haven't seen any proof that Mr. Ambler evaded.
And that's the problem.
What I've seen is that he had an expired registration sticker. That's what I've seen. And I think it's pretty clear from the record that these officers were unaware of that. So, I mean, there's no evidence here of any prior evading. There's no evidence here of any drug dealing. We have not seen any. What they made a big deal about earlier was an expired registration sticker. And I certainly don't have any objection to them conveying, to the extent that we're able to verify this, if we are, that he had a pending charge for an expired registration sticker. And that he had, as the court said, some traffic violations during this pursuit. I think that's all very relevant. Outside of that, I think vague allegations of evading with no proof and vague allegations of drug dealing with no proof are, as the court said, classic 404B evidence, and the parties should have to approach.
These aren't vague allegations, Judge. We're ready to prove it. We can prove it. If we fail, that's on us, and that's something the state can point out, but we're not going to fail.
But what does the prior evading charge, so you prove it up, how does that affect what happened that night?
It's to rebut the state's theory of the case, painting Mr. Ambler as someone who simply failed to dim his headlights. The reason we would like to get into the prior evading is to show Mr. Ambler had knowledge that he had successfully evaded before, and he was attempting to do so again this time. So again, it goes to intent, motive, to keep up the pursuit for the 22 minutes and 31 seconds it took before he could get away. This is not about headlights. And painting it as that is misleading to the jury when there are facts contrary.
Respectfully, Your Honor, this is not about Mr. Ambler's mental state. It is about the mental state of these two defendants and what they knew. And there is absolutely no evidence in the record that they knew anything other than that he failed to dim his high beam headlights and he fled that night. They did not have any other information. And if the defense wants to bring in some proof outside of what we know that they did, I think that's a different matter. But to the extent that there's some theoretical other thing out there that they had no awareness of, it is not relevant to their culpable mental state here.
I'm gonna continue to sustain the motion and eliminate on that front yet, but understand that, let's see, I don't know what the evidence is gonna show. So, but for right now, I'm not going to allow any argument about him evading that they may have been engaged in by the victim. I fail to see its relevance right now. Okay?
Understood, Judge. One more category. So this speaks to number 6, number 9, and number 11, possibly touches on others, but it's the timeline of this case, the incident date, so specifically, date of the incident, the length of time that passed before the indictment, the date of the change of administration, campaign promises and statements from Mr. Garza indicating he intended to seek justice for the family, the date of the manslaughter indictment, the fact that Officer Neeston was not indicted, which I believe is okay now, that's been withdrawn. And lastly, the fact that there has been another indictment for assault from Mr. Johnson this month, this far after. Those are the specific items I would like to reference in the opening statement.
Your Honor, I think this is just exactly what we talked about in pretrial proceedings. It's the politicization of the case. I think that the relevant evidence here has to do with what happened that night, what was involved in these officers' conduct, what these officers were aware of, and none of this has anything to do with that.
It's not a politicization, Judge. It's the fact that this case sat for as long as it did with nothing happening. This is an inference that for 1 year and 8 months, there's an inference that there was a belief that no crime had been committed. There are intervening events, now we have indictments, and then another indictment this month.
Your Honor, I think that
The facts are what the facts are. And what the jury is going to hear is what the facts are and what they were that night. And I understand the defense argument about political motivation and other things, but in this courtroom, we are going to decide this case on the facts. And even if I accept all of your allegations of motivation and everything else to be true, it does not change whatever the facts are. And I don't know what the facts are right now. The jury doesn't know what the facts are, but we're going to try this case on the facts and the law. So I'm going to sustain that motion.
Thank you, Your Honor. And I just wanted to make it clear that the state does not contest the defense's ability to bring their spoliation argument, which they've made clear in pretrial proceedings that they intend to argue. Thus, we think the facts would arguably include the disposition of the live PD footage because that is relevant to a defensive, in my opinion, a defensive claim. The rest of the stuff, I 100% agree with the court's ruling that it is merely politicization. It is not relevant to the facts that occur.
Any other issues, Mr. Irvin?
Judge, specifically with regard to the pending assault indictment for Mr. Johnson, without reference to anything else, can I bring that up now? The relevance is again, the timeline. The fact that now 4 years, 5 years later, there's a new indictment.
It's the same, no.
Also, I know that the court recalls that they objected to the joinder. It's been severed.
We'll get to that when we get to that.
Nothing further from the bench.
Okay. Anything else from the state before, I realize I still have the defense motion, and I'm going to take a brief recess, and I'll be back, but yes, Ms. Taylor.
I was going to ask whether we can have a brief recess as well. We're not.
Yeah, we'll take 15 minutes.
Thank you, Your Honor.
Okay.
Is it in there? It had to. Because I didn't hear it vibrating in here. Thanks, Destiny.
Right. Exactly.